Hello, my name is John Pavolotsky. I'm a member of the IP section of the California Lawyers Association. I'm going to give an IP QuickDate on non-disclosure agreements. We've done a few of these last year on recent cases. We're going to switch gears a little bit and do a few of these on topical issues that an IP practitioner might face. So what is an NDA, non-disclosure agreement, or confidentiality agreement? It's a document by which the confidential proprietary information or trade secrets of one or both parties are protected. Why do you need it? To safeguard your confidential information and to make sure that whatever you worked on to develop and that has value is appropriately protected. You would put this in place before engaging in a business relationship with a counterparty. Yes, suppose you could put in place maybe a little bit after, but you would want the disclosure period to cover the initial disclosures. There are many flavors of non-disclosure agreements, and I am obviously in this 2 to 3 minute presentation, going quite quickly through them. You can have a unilateral NDA, a one-way NDA. It can be bilateral or mutual. It can be multi-party, meaning that you've got 3 or more parties. One thing to consider is that even though an NDA might say that it's mutual, the devil might be in the details, and you'll have to read it carefully to make sure that provisions don't apply only to one party. Coverage is also an important topic, and so it could cover, as mentioned, confidential information, proprietary information, trade secrets, written information, oral information, information during a certain coverage period, and so forth. NDAs focus on use and disclosure limitations or prohibitions, so care needs to be taken in devising them. The duration of an NDA, it can be for 1, 2, 3, 4, 5 years, and then it can have a tail such that the obligations survive the termination or expiration of the NDA. Usually, bilateral NDAs do not have any reps or warranties, or if they do have them, they're very limited. And so there are broad disclaimers such that information is provided as is. Damages limitations usually are not apparent. Once in a while, you might see a party trying to put in a limitation to disclaim consequential damages, and that usually fails in that the main damages from a breach, namely lost profits, would be precluded from that. There are a number of quirky terms as well that one might need to take a look at, including indemnities, residuals, feedback clauses, and privacy terms, and we can cover that in a future presentation. Again, please check out the materials of the IP section, and thank you for joining me on this IP QuickDate.